Good morning, Mr. Soni. Good morning, everybody. Are we ready?
We are ready. DCJ, I must apologize, and so does the witness, Mr. Bouters. He came from Pretoria, but he just lost his way.
Oh, okay.
And he apologizes most profusely.
Okay, that's fine. I thought that maybe the commission didn't give him the correct address. Because I heard that he seems to have gone to the old venue.
That's what seems to have happened.
Yes. Okay, no, that's fine. We are happy that he's here. Thank you, Mr. Portes. Yes, Mr. Soni.
Mr. Soni, before...
yes.
Mr. Chairperson, before we start, may I put Mr. Bouters' evidence in context, and then we can swear him in so that we know what the purpose of his evidence is, and it can be directed at those issues.
No, you can do it, but maybe let's start with him being sworn in, yes. So then you can put his evidence in context, and then we begin. Yeah, thank you.
Please state your full names for the record.
I'm Francios Weideman.
Do you have any objection taking the prescribed oath?
No, I don't.
Do you consider the oath to be binding on your conscience?
Yes, I do.
Do you swear that the evidence will give will be the truth, the whole truth, and nothing else but the truth? If so, please raise your right hand and say, "So help me God."
Yes, I do. So help me God.
Thank you very much, Mr. Portes. Once again, thank you for coming to give evidence. The file that I've got here, has it got his affidavit?
It's right, it's the last one, Chairperson, in bundle G.
Well, I've got bundle H. I've now been given bundle G. Is bundle G the correct one? I've now been given bundle G. I had bundle H.
Oh, I'm sorry.
Okay. Yeah, okay.
Mr. Bouters' affidavits appear at as SS17, and they start from page 1, Chairperson.
From page?
So it's a separate document. Chairperson, the way this file has been prepared is because there are short witnesses with short affidavits, they decided to put everything into one file. Mm-hmm. I don't know if they've put dividers into your file.
Well, I'm not sure what that means. Do you mean that the files have not been paginated in the way they're supposed to be paginated sequentially from page 1 up to the last page?
Yes. DCJ, part of the problem was, and I was not involved in it, was that what we would have is a person's affidavit starting at page 15, or in this case it would be 100 and something, and it was thought that it would be better to have them start with page 1 of the affidavit.
Yeah, no, you remember we talked about it, was it on Monday?
I know this.
Yes. Because we just need to be consistent.
Yes.
It helps me when I pick up a file to know what I'm expecting.
Yes.
If I'm looking for page 50 or 250, yes. I mustn't find that there are two 250s.
Yes.
If I'm looking for page 20, I mustn't find that there are 3 page 20s, sure. In the bundle.
Yes.
And it is a simple thing. It has been done all along. Will you just prevail on those who do this? Because in the end,
Yes.
it's the evidence leader that takes responsibility for this. So when they do it, just check that they've done properly. We don't have a choice now because Mr. Bott is here. We have to continue, but it's not satisfactory.
Yes.
We
No,
need to be able to say on all the bundles, the pagination is from page 1 up to whatever.
No, sure.
Even if there are different statements inside, if they are in the same bundle, the pagination
want it from
covers
page
everything.
1
It's
to-
sequential, yes. Okay, so how do I get to Mr. Porter's affidavit on this bundle?
It's marked Exhibit SS17.
Okay, all right.
I again apologize.
Yeah, okay, all right. They must just fix the one we discussed, was it Monday?
Yes.
If they haven't fixed it, and then they must sort this one out afterwards.
Yes.
Okay.
DCJ, before I lead the evidence of the witness, because perhaps I should place on record the background against which Mr. Botus has been called, because the matters that are contained in the documents before you are much wider than what the Commission is dealing with. But there is a significant part of Mr. Botus's affidavit and statement to the Pretoria Bar Council that contains matters that are of interest to the Commission. But I'll just give the background, Mr. Chairperson. You will recall, Chairperson, that Mr. Ngoyi gave evidence that in regard to the CIA matters, the matters had been in court and they'd been referred to arbitration. There were 5 matters that had been referred to arbitration. And the arbitrations were going to go on, and this now is the perspective from the PRASA legal, the internal legal team. And they were told that the newly appointed chairperson, Ms. Makubela, now Judge Makubela, was going to be dealing with the matter. And you will recall that they said that when they contacted PRASA's attorneys said to them, PRASA's attorneys had been instructed not to communicate with the internal legal team. Then they found out that the matters had been settled and that there was going to be an application to court to make the arbitration awards and or orders of court. When they found out about that, they then approached a firm of attorneys different from the ones that had initiated the settlement or had concluded the settlement to have those orders rescinded. Eventually, it was rescinded. So that's the perspective from the PRASA internal legal team. We are now going to deal with the perspective of the communications between Ms. Makubela and the lawyers for the liquidators in the matter. Mr. Botus was counsel for the liquidators in the matter, and at issue was a communication that Ms. Makubela had made to him saying that the attorneys who were applying for the rescission application had no authority to do so. At issue, again, to put Mr. Botus's evidence in perspective, is that when this application was made, Mr. Botus was surprised, having regard to the fact that in a previous communication, Judge Makubela had said to him, the matters are settled, and the matters, in fact, were settled. So he asked her by way of a WhatsApp message, are you bringing the application? And it is that message that she sent to him to say, those lawyers have no authority. That is an issue in these proceedings, because what it did was, there was massive publicity around the issue at that time. And Judge Makubela then laid a complaint against Mr. Bouters for revealing in court and through his attorneys the communication she had sent to him. So there's no dispute about the communication as I understand it. There is a dispute about whether Mr. Bouters should have revealed it in court. In Mr. Bouters' response to the complaint laid by Ms. Makubela to the Bar Council, he revealed how the communications on this issue started between him and Ms. Makubela. And it is for that reason that we are going to call, we are calling Mr. Bouters. So it's a very narrow issue as far as the commission goes. As between Mr. Bouters and Ms. Makubela, there are other issues that, with respect, Chairperson, they do not concern the commission.
No, that's fine. I think that it's important also to mention other features that you might not have mentioned that make the Commission to be interested in the interactions between the then chairperson of the PRASA board and Mr. Bouters. Namely, that PRASA is one of those SOEs in respect of which for many years there have been in the public domain all kinds of allegations of serious corruption and maladministration. And except for what we heard from Mr. Popo Molefe, who was chairperson of the board of PRASA at a certain stage, except for the attempts that his board tried to do, it appears that not much has been done by anybody to deal with those allegations of corruption at PRASA. And the former chairperson of the board, now Judge Makubela, her assumption of duty and her appointment as chairperson of the board also happened under circumstances that are quite unusual. She appears to have been appointed sometime in October, I don't know if it was the 19th of October,
Yes,
2017. Prior to that, she had been nominated for appointment as a judge of the High Court. And I think early in October, I don't know if it was the 2nd of October, she had been interviewed by the JSC for the position of a judge. Now, so there are questions about why she allowed herself to be appointed when she would have known either that she was about to be appointed as a judge, or that there was a very good chance she would be appointed as a judge. I mean, I'm one of those people who know a lot about what happens in the JSC because I've been interviewed probably about 6 times over the past 23 years. Very often when you have been interviewed by the JSC, you get told either by the same day or within the next day or 2 whether the JSC will advise the president to appoint you. And the role of the JSC and the president also is such that the president, general view is that the president is bound to go along with the advice of the JSC. But even if it was said what the JSC does is a strong recommendation, over the past 20 or whatever years, I think it would be difficult to find any case where the JSC advised the president to appoint a person as a judge and the president did not appoint. So there are questions about why would she have accepted appointment as chairperson of the board when she would have known that in all probability, beginning of the year 2018, she would be expected to assume duty. So there are those questions, and then, of course, part of the evidence of Ms. Ngoye, if I recall correctly, was that after she had arrived as chairperson of, she had arrived at PRASA as chairperson of the board, her interest for purpose of settlement was on CIA matters, even though, according to Ms. Ngoye, there were a lot of other matters with even larger amounts involved. She only showed interest in that one. So it's against that background that the commission wants to see what role she may have played, and then the exchanges that she might have had with Mr. Bottas, that's the context. So I thought I must just mention, because also it's important the public should just have as good the background as possible.
May I, in fairness to Ms. Makubela, Chairperson, say that she has asked to consult with the Commission so that she could answer those very issues.
Yes.
Well, that's what she said to me in a telephone conversation last Saturday.
Yes.
So, but Chairperson, those are matters that will obviously have to be raised with her. But with respect, that is the full background against which Mr. Bottas's evidence must be assessed.
Yes. No, she definitely has recently indicated that she will cooperate, and she makes herself available to be interviewed by the Commission's legal team.
Yes.
And the legal team has been in touch with her.
Yes.
And certainly her side of the story will be heard. I don't know whether, Ms. Soni, you want to say anything about a request for investigations, forensic investigations?
Mr. Chairperson, as I understood what Ms. Makubela said is that because Mr. Bottas's communication to the Commission was based on some WhatsApp messages between him and Ms. Makubela, his phone had been subjected to a forensic analysis by the Commission, and she wanted the same in respect of her phone. We indicated that we would have a person from the Commission's forensic team at the interview, at the consultation with her, and if it was necessary, then those investigations or inquiries would be made. And she would have to indicate what is it that is in dispute between her and Mr. Bottas.
She is aware, of course, is she not, that Mr. Bottas is going to give evidence this morning?
I told her on Saturday, and I called her again last night after we had finished here.
Yes.
So I did tell her that, and she asked if Mr. Bottas' evidence could be deferred until she gave evidence, and I pointed out to her that that is not how the Commission operates. It's in fact very seldom, if it has ever happened, that when a person who is called by the Commission gives evidence, that the person a so-called implicated person is immediately called. But I did indicate to her that Mr. Botus will be called today.
Okay, no, that's fine. I'm sure that she will feel free to pursue if she believes she needs that forensic investigation to do so. My understanding of what she really wants to be revealed by the forensic investigation, because I've seen the correspondence, I've read an affidavit she has deposed to. My prima facie view is that the issue that she wants to be revealed is an issue that does not appear to me to be relevant to the issues that the Commission is looking at. But that's not a final decision. She should feel free to persuade me that it is relevant. And then if I'm persuaded, then we can look at that. And she did mention I think she did mention something about wishing to cross-examine Mr. Botus. But everyone applies for leave to cross-examine, yes. And there are certain requirements that need to be met, one of which obviously will be whether the cross-examination will be on issues that are relevant to what the Commission is looking at or yes. Not. Yes. So she can bring that application or move that application in due course, and if leave is granted, I have no doubt Mr. Botus would make himself available after that. Okay, I think we have put everything on record properly. But if there's something I've left out, you can indicate.
No, Chairperson, just to point out that we will point all of these matters out when we consult with her next.
Yes. Okay, thank you.
Mr. Botus, just if I can ask you, you've submitted to the Commission 2 affidavits, and your response to Judge Makubela's complaint against you to the Bar Council, to the Pretoria Bar Council. Would that be correct, Mr. Botus?
Thank you very much, Chairperson. Thank you very much, Advocate Zoni. Yes, I provided the Commission with 1 affidavit. That's the affidavit that appears on Annexure SS 17 on page 57, 58, 59, and at the top of page 60, that is my signature, which appears on that affidavit. That's the so-called, I see it's marked the 2nd affidavit, and the report that the 2nd or the 1st affidavit is the affidavit that the Commission, Mr. Commissioner, will find SA 17. That's the first page, page 3, 03 up until 06, and that's my signature, which appears right in the middle of the page. And the whole purpose of these affidavits were to introduce the response to the complaint that was lodged by the Honourable Justice Makubela against me, and that response, Chairperson, will find from FWB 08 right until the end, and that will be page 24, and right at the end of that document, I've signed it on the 17th of May, 2019.
Okay, thank you, Mr. Sonny. I thought you should start by getting Mr. Botus to tell us who he is. He is an advocate in which bar, for how long he has been in practice. Those preliminaries, just get them out of the way before we go into the affidavit.
Chairperson, I've studied at the University of Pretoria, obtained the degrees BLC and LLB. I joined the Pretoria Society of Advocates in 1996. I did pupillage, passed pupillage, and I commenced practice in 1997. The 1st of December 1997, sorry, I did pupillage in 1997, passed pupillage and commenced practice on the 1st of December 1997. I remained a member of the Pretoria Society of Advocates. I'm still a member of the Pretoria Society of Advocates. I was elected to the Bar Council in 2005. I was elected as the Deputy Chairperson of the Bar Council during this period, which is relevant for purposes of this commission. I served as the Chairman of the Pretoria Bar Council 2 years ago, and I was recommended for senior status in 2013, and the former President Zuma, signed my letters patent in September 2014.
Thank you. I think that's the background that I wanted us to deal with first. Yeah.
Mr. Burgess, do you know Ms. Makubela?
Chairperson, I know Judge Makubela very well. I know her since I've commenced my practice in 1997. We were members of the Bar Council for many years, and we have developed a very, very good relationship, a very cordial relationship. I always encouraged her, jokingly and seriously, that she's ready to be appointed, she's ready to grace the bench. And whenever I saw her, I said to her, but come on, you must do it now, the time is right. And we really, really established a very, very good relationship based on integrity, based on trust. We were never opponents in matters. We were never involved in litigation, but we really, really got along very, very well. And I knew that she was about to be interviewed by the Judicial Services Commission. I also knew that in early October 2017, that the Commission sat, the Judicial Services Commission, and I also knew because in our society, when one of our members receive news the evening or the day thereafter that they've been recommended, it spreads like a veldfire in our society, and we're also proud of it. We pride ourselves to make our members available to do judicial service. And I was very pleased. I did unfortunately not phone her at the time. I was a little bit busy with other issues. And when I received her call early in November, I was in my vehicle traveling from or to a destination. I had a cell phone number on my cellular telephone, and when the phone rang and it said Nana Makubele, my first reaction was to congratulate her. I said, Nana, this is now a very pleasant call. Congratulations upon your appointment. My submission was it was overdue, but I wish you a very pleasant, a very prosperous career on the bench. And my words were still, hopefully we will see you in higher echelons and maybe an appointment in the SCA. And Judge Makubele was extremely friendly, like she always is. She is a friendly person. I've never experienced any animosity between us. And yes, so that is how the conversation started. I was totally unaware of her being appointed as the chairperson of the interim board of PRASA. It was never brought to my attention. I was simply totally unaware of it. And when she informed me that she was appointed as the chairperson of the interim board, it didn't come as a shock, it just came as a surprise. I said, oh, well, that's good. Good to hear. I did not know what the purpose of the interim board was. I don't know how long a tenure would have been. I don't know what the background was. That was the first time that I have learned about her appointment. I thought that, well, now that she's appointed in that position, maybe the purpose of the phone call is to engage my services in some manner or another. And I asked her, how can I be of assistance, Judge Makubele? And she said to me that she was appointed as the chairperson of the interim board by the former president who deployed her there. And I asked her, but for what reason? And she said to me unequivocally and in no uncertain terms, to sort out the mess at PRASA and to clean up. Those were her words. She then mentioned to me that it came to her knowledge that I am involved in pending litigation where Siyaya Consulting Engineers is or was the plaintiff. I said to her, yes, but before you go any further, PRASA is represented by Senior Counsel Advocate Kennedy Tsatswane, who is the current chairperson of Johannesburg Bar Council, who I know very well and who I have a very, very, very good relationship with. And this matters, there were 5 matters. These matters have a history. It's not something that just came about. We are literally, chairperson, engaged in high profile litigation. If I just can go back one step, I got involved in the 5 matters during 2017, and that was when all these matters were set down for hearing on the same day in Pretoria High Court, and at the call of the roll before the Deputy Judge President is Judge Ledwaba, that was on the 30th of May 2017, the liquidators for Siyaya and PRASA's team of attorneys, led by Advocate Kennedy Tsatswane Esi, decided, let's consolidate all 5 of the matters and refer it for arbitration, because the issues, chairperson, were crisp. There were 2 primarily issues. One, did Siyaya do the work that are reflected and contained in the invoices? If that is so, the next question is, what should the quantum be? That was the litigation. We then prepared draft orders. We provided the court with those draft orders, and we then subsequently decided to engage retired Judge Fritz Brandt, who retired at the Supreme Court of Appeal, to hear all these matters by way of arbitration. We made an appointment here in Sandton at the chambers of Advocate Tsatswane Esi to meet with Judge Brandt. We ironed out the formalities and the procedure. There were definite timelines that we agreed upon, when to discover further particulars, experts, etc., how many days we had in mind for the arbitration to be conducted, etc. And all of that fell in place like we have arranged and how it was agreed upon. However, chairperson, this arbitration never got out of the blocks. This kite didn't get into the air for various reasons. One of the reasons were that further particulars from our side were not forthcoming. We were struggling to get information, but be that as it may. Judge Brandt was always available. He said to us, when you guys have sorted out your internal housekeeping, phone me, I'm in Stellenbosch, we can make an arrangement, we can arrange dates, and we can let this arbitration get on its way. So that's the background to my involvement in the matter. But also noteworthy, chairperson, there were 2 attorneys, firms of attorneys involved on behalf of Siyaya. It wasn't only Siyaya, there were 2 companies. Siyaya Consulting, which were in liquidation, and another company which were not in liquidation. So the attorneys who dealt with this matters from the inception, I only got involved shortly before the trial, in May 2017. That was Mr. Tsepu Matopo. He's a well-known attorney in Johannesburg. And Mr. Matopo and I went through all the pleadings, all the documents, chairperson. The discovered documents were literally thousands and thousands of pages, 90% of it totally irrelevant, but be that as it may. And also Mr. Johan Krause from Krause Incorporated. He was in Pretoria, and he also played a role because he was not only Mr. Matopo's correspondent in Pretoria, but he was actively involved in these matters. Be that as it may, Judge Makubele, just to turn back to our conversation, our telephonic conversation, I said to her, Nana, PRASA is represented by Mr. Madimpi Mogashua from Diala Mogashua Attorneys. He's a very senior attorney, and PRASA is represented by senior counsel and junior counsel. Why are you phoning me? And she said to me, I don't trust the internal legal department of PRASA. I don't trust what is being conveyed to me. The attorneys, she used the word, is captured, and she feels that she's been undermined. And I said to her, but why me? Why do you phone me? She said, no, I want to establish the true facts. What is going on in this litigation? What's the status of this pending litigation? I said to her, summonses were issued, pleas were filed, initially bare denials, later on amendments were effected. I told her about the pending arbitration before Judge Fritz Brandt, and she asked me if I can give her more information. I said, Nana, what I can give you is the pleadings, the summonses in each of these matters, the pleas. There was an insolvency inquiry, chairperson, that was conducted over a period of 5 days in September. The commissioner prepared a very, very thorough report. I was in possession of that report. I can provide you with that report. And there was also a transcription made of the insolvency inquiry. Just to put you in the picture, why did we decide to initiate an insolvency inquiry? Mr. Matopo and the liquidators at the time thought it was prudent to decide or to determine for once and for all, are we chasing a ghost or is there genuine merit in these matters? For good reason, because the estate didn't have the funds to litigate ad infinitum and just to waste money. There were claims by former employees and creditors, and Mr. Matopo and the liquidators' view was, we don't have that luxury of a war chest worth of millions that we can litigate. Rather err on the side of caution, and that was also my advice. And we then decided, chairperson, rather spend 3, 4, or 5 days in the insolvency inquiry, call these witnesses from PRASA, who was personally involved in these projects, and to find out from them, was the work done? Is the monies due? What is the problem? And if their evidence is, listen, the liquidated or the plaintiff, the liquidated company or the plaintiff didn't do the work, or there was fraud or whatever, then we would have known how to advise the liquidators so that they can report back to the creditors, the concursus creditorum. So having said that, that is exactly what we did, but I made the decision to inform Mr. Mogashua and to invite Advocate Kennedy Tatswane to be present at the insolvency inquiry. I said to them, guys, be present. You can hear with your own ears what these witnesses are going to testify to, and then you can also decide how you want to go about. If they decide, or if their evidence under oath is detrimental towards the plaintiffs, well, then so be it. And vice versa, because we cannot carry on like this and just waste hundreds and hundreds of thousands of rands in litigation. Both Mr. Mogashua and Advocate Tatswane Essie accepted my invitation. They were present. We called witnesses, Chairperson, witnesses who was personally involved in these matters, and they testified. I asked them questions, listen, this project, what was done, etc., etc. All of them had no reservation to testify in front of the commissioner, and their evidence was proper presented. I also provided Advocate Tsatswane Esi an opportunity to cross-examine the witnesses. That's on record. I said to him, Kennedy, you're welcome, cross-examine the witnesses. He said, no, it's not necessary to do so. They reserved their rights. So what Mr. Krieger, he was the presiding officer in the insolvency inquiry, he prepared a report. To cut a long story short, Chairperson, I made myself available. I took it upon myself and I said to Judge Makubele, no, what I will do is I will make copies of all the pleadings, the summonses and the pleas, the insolvency, a copy of the transcript of the insolvency inquiry, and Mr. Krieger's report. So that will give you a clear indication of what the status of the matters are. She asked me, what do you think? What's your view? I said, the evidence that was led in the insolvency inquiry, I'm not convinced that the quantum has been addressed. I think that's an inquiry for another day. But that some of the work was done, yes, it seems like it. There was one witness, Chairperson, who said that he still wanted to go and do a quantification. He wasn't 100% sure, and we allowed him that opportunity. Be that as it may, Judge Makubele then asked me, will I then collate those documents, which I did. And I then, after our conversation, Chairperson, I immediately, like the next telephone call, alerted both Mr. Matopu and Mr. Krause, because having regard to the ethical rules, I was extremely, I won't say nervous, I won't say anxious, I was worried. And I informed them, I said, guys, it's very important that our approach in this instance, and specifically what transpired now, we must either continue on this path or we must terminate this communication, because this can lead to big problems. We then took the decision, assist the judge. Judge Makubele was appointed as the chairperson of the interim board of PRASA. Assist her insofar as we can, but remain alerted. Don't go into the arena and don't do anything that's unethical. And very important, we communicate with each other. Me communicating with the two sets of attorneys and me communicating with Judge Makubele, everything was transparent. I then prepared the bundle, I indexed the bundle, I paginated the bundle, and I made an appointment to meet with Judge Makubele at the offices of PRASA, and that happened on the 14th of November 2017. Judge Makubele explained to me where PRASA's headquarters were, Chairperson. I've lived in the vicinity as a student because it's in the heart of the student community. I attended the building. I was taken up to the top floor, very impressive, and I was invited into a big boardroom, and I sat there, and I was armed with my bundle of documents. Judge Makubele entered the room, once again, very friendly, very cordial, very humble. She's a humble person, and she discussed the various matters with me. I told her what the bundle of documents consisted of.
I want to interrupt you, Mr.
Sorry.
Portes. I'm very sorry.
Sorry.
Maybe it's not so serious. I wanted to tell you earlier, in her affidavit, she also says you are a very good person. I think she said you're charming.
I'm not going to concede that.
There is a part where she says, you are a very good person. know each other quite well, and you're friendly and so on. So I just thought, because you have been saying very good things about her, I must just tell you that she also has
Thank you.
good things to say about you.
Thank you.
Yes, I interrupted you, I'm sorry.
Thank you. No, Chairperson, I don't want to delve into matters which are irrelevant. The long and the short is, I provided her with the documents, and I also said to her, take these documents, take it to whoever, the board, study these documents, make up your mind, but we must somehow or another get the arbitrations finalized. It's not in the interest of justice to let this matter just prolonged. And that, in essence, that was it. Then, and allow me, Chairperson, Judge Makuvele and I communicated via WhatsApp and telephone calls regularly thereafter. All of those WhatsApps, all of those communication I revealed to the investigators of this commission. I had no objection whatsoever for them to make copies of my cell phone. They made a mirror copy of my cell phone and my iPad, which I have with me. I've got absolutely nothing to hide, and there's absolutely nothing untoward what happened. Then it culminated into a settlement. In December, Chairperson, Judge Makubele and I, during our discussions, she then informed me that PRASA's board was satisfied that the work was done, the money is due and payable, and that these matters should be settled. And I said, very well, if that is the decision, well, then that's the decision. Inform your attorneys as such so that we can get the boat or the train out of the station. Mr. Madimpi Mogashua then prepared a formal tender in terms of Rule 34 of the Uniform Rules of the High Court, and that tender entailed, Chairperson, the capital amounts in all these matters. I then informed Mr. Matopu and Mr. Krause, that's not how I understood the communication between Judge Makuvele and I, because she also mentioned interest, and there's also a letter to that effect, which PRASA's interim board dispatched to the attorneys, in which they instructed the attorneys, make the tender and provide for the capital plus interest, but not legal costs. So then there was communication exchanged, and eventually a letter came back and said, sorry, we made a mistake, it's the capital plus the interest. The interest was then calculated, and I prepared then a draft awards, because the plan was to inform Judge Brunt, don't spend any more time on these matters. We've reached the settlement. What we will do is we will approach you, and then you can make the settlements and award. And I took it upon myself, Chairperson, to prepare those awards. Those awards are attached to my affidavit. And I dispatched the awards to Mr. Madimpi Mogashua. He took instructions and he was satisfied. There's also correspondence to that effect. Judge Brunt was coincidentally busy with an arbitration in Pretoria at the offices of Adams & Adams Incorporated in Brooklyn Bridge. He then communicated to us, he said, guys, if you're on the same page, I can make myself available in a lunch hour. Whenever it's convenient for you, come, and then I'll make the awards of the arbitration. But Judge Brunt asked me and Mr. Mogashua both to be present, because he wants to be satisfied that this is a proper settlement. His words to us were, I don't want to come back here. And that is exactly what we did. I prepared the draft awards. We then made an appointment, and we saw Judge Brunt at the offices of Adams & Adams on the 7th of February. I just want to get the exact, lay my hand on the exact date, Chairperson. That was on the 7th of February 2018. And Judge Brunt made all these awards of the arbitration in my presence and in Mr. Mogashua's presence. We were all satisfied a settlement was reached. And that is pretty much when the communication between myself and Judge Makubele also stopped, because there was nothing more to communicate about. Everything was settled. But Chairperson, money wasn't forthcoming. Money didn't flow. There was provision made where the money should be paid into Mr. Krause's trust account. And what subsequently transpired, but I didn't play a role in that, is that the attorneys then decided to bring an application for these awards to be made orders of court in accordance with the provisions of the Arbitration Act, and I became involved. Then I prepared all the applications, the notice of motions, the founding affidavits with the annexures, and all those applications were properly served on Mr. Madimpi Mogashua's office, and they were set down for hearing in Pretoria on the unopposed motion court roll for Friday, the 9th of March 2018. In that week, the attorneys for the liquidators started receiving correspondence from Bowman Gilfillan. Correspondence to the effect that their instructions are to oppose these applications. Mr. Matopu, Mr. Krause, and I, Chairperson, had various discussions. And our biggest challenge was, what do we do about this? Should we say to them, very well, we're going to remove the matters and allow you an opportunity to file affidavits, or are we going to persist with these matters? And we then decided, let's rather give them the benefit of the doubt and ask them to produce authority in accordance with the provisions of Rule 7 of the Uniform Rules of Court. Unfortunately, they couldn't. They couldn't provide us with a board resolution or a piece of paper which emanated from PRASA's board that they are duly appointed as PRASA's attorneys to oppose these matters. We then said to ourselves, well, if they're unable to do so, let's proceed with these matters. On the 9th, Friday the 9th, 3 applications with the unopposed motion court roll before one judge, both acting judges, acting Judge John Hollandmuter and acting Judge Peterson. Bowman Gilfillan, on the instructions from, I assume, PRASA's legal department, instructed counsel who was at court with the whole team. I think Mrs. Martha Nagoya was also there. Other gentleman whose name also appears in the papers, Mr. Fani Dingishayo, he was also present. And we started interacting with these people, their colleagues. And I said to them, but guys, how on earth can you oppose these applications without a mandate? And they, Chairperson, they persisted. They said, but we have a mandate. We are entitled to be here and to oppose these applications. And my response was, but on what basis? We've settled that. There's the awards. And they said, listen, we were not consulted in all of this. We want an opportunity to ventilate the disputes and to put our version before the court. I took it upon myself, Chairperson. This is where the dispute emanated from what I did. I then dispatched a WhatsApp or an SMS to Judge Makubele, and I asked her, does Bowman, or did PRASA's board instruct attorneys Bowman Gilfillan, all counsel, to oppose these matters which have been set down in this court? And her response forms part of the correspondence in which she unequivocally answered back to me, and she said, no, they do not have that authority. They do not have instructions on behalf of PRASA. And Chairperson, I was satisfied with that message on my cell phone that we were right. We were entitled to persist in the applications and to ask for judgment. We then, my colleague and I, on behalf of PRASA, under the instructions of Bowman Gilfillan, approached Judge Peterson and said to him, we don't think it will make sense for 2 courts to hear exactly the same set of facts. It is the unopposed motion court. They're going to apply, or PRASA's going to apply for a postponement so as to give them an opportunity to enter into the litigation. Can't we take the 2 or the 3 files with him and transfer it to Court 2A to Judge Holland-Muter, and then we can make our submissions before Judge Holland-Muter? He allowed us to do so. And when I stood up eventually after all the unopposed matters were entertained, I directed Judge Holland-Muter's attention to what we are dealing with, what the whole background and the history is, and I also said to him, our learned friends are here today because their instructions are to oppose and to prevent these matters from proceeding today. And Judge Holland-Muter asked me, do you know on what basis? And I explained that to him. So then the arguments commenced before Judge Holland-Muter in open court, and Judge Holland-Muter quite correctly said to me, but Mr. Botha, it's either they have instructions, there is such a decision by the board, or there isn't. I mean, if there is such a decision, I'm not going to give judgment to the tune of more than 45 million rand if the opposition is bona fide and genuine. And I said, but of course not. I agree 100% with you. So all that I can present you with, my lord, is my cell phone. There's Exhibit A. This is the question, and there the answer comes. And Judge Holland-Muter took it into consideration. And Chairperson, when he read it, he said to my opponent, but is there anything better? I mean, are you going to present me with something better than I have in front of me? And they said no. And on that basis, judgment was granted in each and every of these matters as applied for in the notice of motion. And what transpired then is Mr. Matopu and Mr. Krause instructed, armed with these judgments, applied for a writ to be issued by the registrar in Pretoria, and then instructions were given to the sheriff in Pretoria East, Mrs. Lana Burger, to attach the funds in PRASA's account. Chairperson, don't keep me to it, but it was in excess of 60 million rand. Or just below 60, or just in excess of 60 million. But it was a substantial amount of money. And the sheriff executed those writs, attached the monies in PRASA's bank account. It was withdrawn and kept in her trust account for I think the 14-day period or the 15-day period to expire, so as to give PRASA an opportunity to do whatever they deemed prudent in the circumstances. That's what Advocate Sony referred to. That was then met with an urgent application, actually 2 urgent applications, one in Cape Town, which is irrelevant for purposes of this inquiry, and one application in Pretoria, where PRASA asked for interim relief pending an application to have those awards made by Judge Brandt on the 7th of February 2018, to have that reviewed and set aside. Although they asked for interim relief for the sheriff not to pay over the funds to the liquidators pending this process. I wasn't involved in the application because I had other commitments in Umtata, but the liquidators briefed senior counsel from Johannesburg to attend to the application. The application came in the urgent court before His Lordship Mr. Justice Ranshot, and Judge Ranshot's view was a proper case has been made out for interim relief. There was a prima facie case, and so he granted an interim order. And eventually, Chairperson, the matter became, there was a return day. The return day came before the Honourable Mr. Justice Neil Tichten. There wasn't opposition. Our stance was, we had to decide, are we going to oppose this application? But Chairperson, regard being had to the serious allegations that were made by PRASA's legal department in their papers, my view was, and my advice to the liquidators was, listen guys, one, if half of this is true, I mean, there are serious problems. I mean, somebody is playing with fire. And secondly, how are we going to rebut it? We don't know. I mean, we're simply standing outside in the cold. We've got no idea what the internal mechanisms and workings are. I wouldn't advise anybody to throw good money after bad money and to oppose these applications. Rather, allow them an opportunity, set it aside, set the awards also aside, but go back to Judge Brown and start afresh with these arbitrations. And that is exactly what happened. Unfortunately, or fortunately, Judge Tichten had all the documents before him. He didn't have any opposing affidavits before him, but, Chairperson, he correctly, in my view, deemed it prudent to prepare a proper judgment, which he did. He considered all the facts before him, and he made certain remarks pertaining to the manner in which these matters were attended to and conducted. He mentioned Judge Makuvele's name in his judgment, and that led to two issues. One, the complaint that Judge Makuvele initiated against Judge Tichten. I read the complaint. I had the opportunity to read his response, and that was referred to the Judicial Services Commission, and he was subsequently found, the Judicial Services Commission, under the chairmanship of the Honourable Justice Goliath, then found that there were no merit in the complaints against Judge Tichten. But similarly, there was now this complaint against me. And the veracity of the complaint, Chairperson, was that the communication between Judge Makuvele and I, she regarded as personal and as privileged. That is what she said in her complaint. And she was extremely upset because I have provided the court with this specific message, and she, in her view, that was untoward, that was not the manner in which she thought that the matter is going to be dealt with, notwithstanding earlier messages, which are also canvassed and provided for in my report, which since the inception of our communication, she sent me a WhatsApp and she said to me, Francios, it is of paramount importance that we are transparent, we play open cards, we are above board. We don't want to become embroiled in a situation, he says, she says, or there is something unethical. And that is also contained in this, and I was very comfortable with that. Chairperson, when I received the complaint, like all of us are, you are disappointed. The complaint was filed in a lever arch file. I think it was more than 150 pages. And I literally had to sit and to work through this because a lot is at stake. I'm Deputy Chairperson of the Bar Council. I'm the Chairperson of the Financial Committee of the Pretoria Bar. I'm Senior Counsel. I've been acting various stints in Pretoria. This is serious, and I prepared a very comprehensive answer or response, which then served before the Professional and Ethical Committee of the Pretoria Bar Council. Chairperson, I believe that invitation was extended to Judge Makuvele to reply to the allegations. My response, Chairperson, was approximately 55 pages, because I realized that I've got one opportunity to tell the whole story, exactly which I did. I believe that Judge Makuvele then decided not to reply to the allegations that I made, and I was informed just before the lockdown this year that the recommendation by the Professional and Ethical Committee to the Bar Council was that they've thoroughly investigated the complaint, and there was no, I didn't make myself guilty towards any unprofessional or unethical conduct. And then I received a letter, Chairperson, from the Bar Council on the 22nd of May this year, that the Bar Council has also decided to vindicate me from the charge.
Thank you very much, Mr. Portes.
Yes.
I think, Mr. Soni, you didn't have to.
I just was a spectator.
Of course, he knows exactly what the issues are, and he has been very involved. Obviously, if there are some things that you want to cover or clarify, but that was quite comprehensive. Thank you, Mr.
And I
Portes.
didn't want to interrupt.
Yes, no.
It told the whole story.
It was fine. It was quite comprehensive. I doubt if I have any questions, but let me allow you to ask if there's anything to ask.
Ms. Burgess, it's more housekeeping for the purposes of record. Now, your response to Judge Makubela's complaint against you, I've not called her judge because at the time this happened, she was not a judge. Although she'd been appointed, so perhaps I should call her judge. Is starts at page...
Well, the appointment was to take effect the following year.
Correct.
Yeah.
Yes.
So technically, when she started communications, she was not a judge yet.
Yeah, I said that, Judge.
She had been recommended for appointment. She became a judge when the appointment took effect. That's my understanding of how these things go.
I must accept that, Chairperson, but in an application in Cape Town, Unite Behind, and that's the complaint before the Judicial Conduct Committee, say that as soon as the pronouncement is made, she becomes a judge. I just make the point that, and that's why I've been a bit hesitant.
No. It's fine. They've put that.
Yes.
We have our own understanding. When I was appointed as an acting judge in 1997, I think I got the letter of appointment early in January, and my acting appointment was to start on the 1st of February 1997. Between the time when I got the letter and the time and the 1st of February, I didn't go around saying I'm a judge, I'm an acting judge. And my colleagues in the profession didn't start calling me a judge. But I'm just saying how I understand it. Yes.
Ms. Burgess, so you made this affidavit at the request of Mr. Ollerman from the Commission on the 14th of October.
Correct, Chairperson.
Now, again, it's not to test anything there, but to the affidavit, you attach your response to the complaint by Judge Makubela, and that's marked X, is that correct?
That's correct, Chairperson.
And then to that complaint, you also, to that response, you also attach a few documents.
Correct, Chairperson.
The one document that you attach is this letter that contains the communication that became the source of controversy, if I can put it that way.
That's correct, Chairperson.
The
That's
one
the
you
letter
showed
dated 8
to
March
the judge.
2018.
Yes. So this is the letter at the 8th of March. This was written by your attorney, but I just want to point out that Judge Makubela takes offense, or she's unhappy that you communicated it to your attorney, and I'm going to deal with that in a moment, but I just want to put it in perspective. That's the importance of this letter. Would that be correct?
That's how I also understand it, Chairperson.
And then you also annex as B the report of the liquidator.
No, that's the report of the Commissioner.
The Commissioner, sorry.
Yes.
Yes.
He had to report to the Master of the High Court what the status of the inquiry was, because the inquiry was then postponed sine die on the last day.
Yes. Now, in regard to this document, in her communications internally to the PRASA legal team, Judge Makubela says that this is the document that persuaded her that PRASA has no defense. I'm just placing that on record. But did you give her this document before she made up her mind? I think you met her on the 14th of November at the PRASA building.
Chairperson, the reason why this was provided to Judge Makuvele on that very first meeting, you will see that if you turn the Annex B, you turn the page and you see there's a 2. That's my handwriting. I paginated the whole bundle, and it started on page 1, and this was the first document in this bundle of documents which I provided Judge Makubele with when I saw her for the first time at PRASA's office, and attached to this was the pleadings in the various matters which were pending.
And then you attach as C a further communication by Judge Makubele to you, and this is a WhatsApp message.
That's correct, Chairperson.
And what is the relevance of this?
The relevance of this document was to demonstrate that all communication between Judge Makuvele and I were open, were transparent, and there was no suggestion by either her or myself that we are communicating within a privileged space. In other words, we shouldn't disclose our communications to any third parties, especially not bring it into the open public domain, because it's between two counsel, two silks, who communicate and attempt, and may I add, a very, very serious attempt to settle all these matters. And I took it upon myself from the first day that we've communicated with each other to share, Chairperson, each and every WhatsApp, each and every email, each and every SMS to Mr. Matopu, to Mr. Krause, and also to those who have formed part of our team. Nothing was swept under the carpet. Nothing was kept in secrecy. Everything was properly and transparently disclosed to those concerned.
Mr. Soni,
Yes.
when Mr. Portas was giving evidence, I didn't have to look at documents. I focused on listening to him. Now I have to look at them because you are referring to them.
Yes.
Just tell me again where you are and how this sequence works.
That's page 45, Chairperson, SS 17. Page 45.
Page 45. Is that the one that has got a C?
That's the one.
Oh,
That's C,
okay.
yeah, that's Annex C to my response to the
Okay.
Bar Council.
Okay.
That's where Judge Makuvele said to me, I forwarded the letter to PRASA with instructions to inquire from Mohashua if he received this and to forward same ASAP. Our instructions were transparent. Hence, I forwarded a copy to you. The intention was to have an open discussion with you and our attorneys, but due to your unavailability, we instructed him to engage with your clients. I think the correctness of the calculation of interest will be verified by PRASA Finance. The principle is acceptable, and those were the instructions. The suggestion, Chairperson, that was how we understood it from PRASA's legal team is that the board of PRASA wasn't aware of what was happening here. Somebody was on his or her own frolic, and the legal department was kept in the dark. So was the other members of PRASA's board also kept in the dark. And why I decided to attach this document to my response to the Bar Council, Mr. Mohashua, in correspondence, took exception to one communication that I have forwarded to him, and I've alluded to it a little bit earlier on. You would recall that I testified that Mr. Mohashua tendered to pay the capital of the 3 or the 4 matters. He directed an email to me to that effect, and I responded. And I was naughty because I said to him, no, that's not your instructions. Your instructions are to tender capital plus interest. And he then said to me, but how do you know what my instructions are. I said, well, these the email I received. The chairperson, when she dispatched your instructions to you, she copied me into it.
So, of course, you would know that it would be quite surprising to the attorney on the other side if he was unaware of the communication. To say, how do my opponents know what my instructions are? But what you are saying, and with reference to this email, or was it a
WhatsApp,
email? WhatsApp message,
chairperson.
is you are putting it up to substantiate what you were saying, namely your communications with the chairperson of the board were transparent, were meant to be open and transparent, and that is why you felt quite free to say to Mr. Mohashua, those are not your instructions, because I know what your instructions are, and the chairperson of the board did not intend that I keep this secret.
Chairperson, quite correct. And if you just turn the page to Annexure D on page 46, that is the letter that was dispatched to Mr. Mohashua by the group company secretary of PRASA at the time. Chairperson, you will find that at the foot of page 48, it was signed by Lindikaya Zide, Group Company Secretary, on the 15th of December 2017. I was copied in this document. That's how I got hold of it. And this is also the document that formed part of when we had the 4 unopposed motions set down on the 9th of March 2018 before the Honourable Mr. Justice Hollandmuter. I had this document in my possession and I gave it to my opponents. I said to them, there's the instruction. You must verify the correctness of this, because this is not sent under the hand of the chairperson. I got the impression, right or wrong, is that represented a board resolution. That's the reason it was signed by the group company secretary. But I couldn't take it further, Chairperson.
Mr. Curtis, just on that point.
I'm sorry, Mr. Son. I see we are at 12:30, actually nearly 25 to 12.
Oh, I'm so sorry.
We're long past, quarter past 11. But what's important is how much more time do you need with Mr. Porter's?
I'm going to need at least 15 minutes, to be fair to Judge Makubela, so
Yes.
that I can put what she has now responded by way of
Yes.
affidavit.
Yes.
And I just
To put
need
her
to
side
put
of
that,
it, yeah.
and then of course her affidavit will come at a different time.
Yes,
But
yes.
I did undertake to her
Yeah.
that I will put her version to
Yes.
Mr. Bouters for him to respond.
No, that's fine. My own understanding is there seems to be the disputes, this is very narrow, very limited. Yeah.
In fact, I could do it in about 5 or 10 minutes, Chairperson, and it may be
Yes.
better because then we can
Yes.
release Mr. Bouters for one.
Yes.
But then we start with something new when we come back.
Yes, no, that's fine. But I think let's take the tea break now. Let's make it 15. I was thinking of making it 10, but that we might rush
Yes.
too much. 15 minutes, so we will resume at 10 to 12.
As
And
you
then with the aim that we should finish about 12 o'clock, 5
Yes.
past 12 or thereabouts.
Yes.
Okay, we are adjourned.
As you-
All right.
Okay, let's proceed. Put on your mic, Mr. Sonny.
Sorry, Chairperson.
I don't know why you always forget.
I'm sorry. Annexure D to your complaint to your response to Judge Makubele's complaint. Where did you get it from?
Chairperson, I got this,
Sorry,
page 46, Chairperson, page 46.
46, okay.
Yes. This document I've received electronically via email from Judge Makubele.
it was about the time that the letter was written, which would be around the 15th of October.
Chairperson, it
December.
was either 15th of December 2017. It was either the same day or the day thereafter.
Right. And then-
Just be mindful, the 16th was a public holiday. I have every reason to believe I received it on the 15th.
And then annexures E, F, G, and H are in fact the awards, the arbitration awards issued by Judge Brandt.
Quite correct, Chairperson.
Now, I take it these are all the documents, the only documents you submitted to the Bar Council.
This was these documents and my response
Yes.
were the only documents that I've provided the Bar Council with. Quite correct, Chairperson.
And the Bar Council then effectively exonerated you. They said that there was no merit in Judge Makubele's complaint against you.
Just before that, how our internal bar affairs work. Once there's a complaint, especially if it's a complaint from a judge or a minister, or that is referred to the Professional Ethical Committee chairperson. If it's a complaint against a senior member, what we normally do is we constitute a committee comprising of more than one senior member to investigate and to have regard to all the evidence, so to speak. In this specific instance, there was more than one silk who investigated it. I don't know who comprised of the entire committee, but I was informed subsequently that the decision of that committee was unanimous to make a recommendation to the Bar Council, because the subcommittee only make a recommendation to the Bar Council. The Bar Council can still decide whether it accepts that recommendation or not, because the same papers serves before the Bar Council. And that's what emanated in the letter of the 22nd of May 2020, that I was exonerated by the committee and by the Bar Council.
Chairperson, just for the record, that letter from the Bar Council appears at page 62, Chairperson.
That's the last letter in this bundle, quite correct, that's page 60.
Yes, I see it. Thank you.
Now, after you submitted your first affidavit, you were asked to make a further affidavit, and that is the second affidavit that you've already referred to, which you made on the 20th of May this year.
That's quite correct, Chairperson.
Now, I just want to confirm again that what's contained in the two affidavits you made is true and correct.
Yes, Chairperson, I take my responsibility and my duty, not only as an officer of court, but also as a citizen of the Republic of South Africa, extremely it's important for me that we should get rid of what's not supposed to be in society. So I'm a very serious person if it comes to the values enshrined not only in the Constitution but also in all the legislation.
Now, Ms. Burtis, I want to get to the last part. In both the affidavits, you refer to your response to Judge Makubela's complaint.
Correct, Chairperson.
And you confirm the correctness of what's contained in the response as well.
Unconditionally and irrevocably, Chairperson.
I just want to now come to the nub of the dispute between you and Judge Makubela as contained in her affidavit. There are two areas of dispute, and I'll just put them to you. The first is she says that it is not you who initiated, it is not she who initiated the communication in relation to the CIA matters, but it is you. Now, you deal with that in paragraph 11 of your affidavit, and you've already given evidence on that.
I must just check something, Mr. Soni. You might have read her affidavit much more thoroughly than I did. At some stage when I was reading it, I wasn't sure whether she comes out categorically that Mr. Burtis initiated the discussion. I seemed to get the impression that she was not committing herself, but she was saying, I want a forensic investigation to be done on my cell phone as well to determine who initiated, without her saying he initiated or I initiated. I know that what I'm saying is certainly true in regard to maybe other things, but I'm not sure. So I'm just checking whether it's something that you had a look at carefully, that she does say he initiated. But if you are sure, that's fine.
Mr. Chairperson, I perhaps looked at the affidavit with, if I may put it, jaundiced eyes, because it was informed by my conversation with her. In my conversations with her, all my conversations,
she's quite clear.
she is adamant that that is the nub of the dispute.
Okay, no, that's fine. I mean, I when I was looking at it, I was saying, at least on the impression that I had, I was saying, well, she needs to put up her version first, so that we know if there's a dispute, there's an issue, before we can have a forensic investigation, because there is no point in having a forensic investigation if there is no issue or no dispute on the issue. But I think put it to Mr. Burtis, because
I will certainly put it, and it's just for his, so that when she comes, we can say that we have put it to Mr. Burtis. Mr. Burtis, you've heard that, and I just want to say to you, in paragraph 11, you respond to what you point out in paragraph 10, namely her allegation that it was the liquidators who approached her through yourself around the second week of November in regard to this dispute. And what is your reaction to that? And I ask purely for I know what your evidence was, but I'm just asking as a response.
Chairperson, to put Mr. Soni's statement to me in perspective, that is what one of the complaints were that Judge Makubele laid, and that was the allegation. May I just direct your attention to page 11 of the bundle, and that is paragraph 10 of my response, in which I verbatim clarified what Judge Makubele said in paragraph 9.1, chairperson of her statement. That was the complaint that she laid. She says, the liquidators approached me, in brackets, first through Advocate Burtis SC, on behalf of this, on or about the second week of November 2017, close brackets, followed by a letter, in brackets, towards the end of the month, close brackets, to intervene in a dispute that had ensued with regard to whether there was a need to proceed to arbitration in view of the evidence at the inquiry. And premised on that, Chairperson, I then put the correct facts into perspective in paragraph 11 of this document. To answer your question, Advocate Sony, one, I was totally unaware of the fact that Judge Makubele was at PRASA. I labored under the apprehension that she was recommended by the Judicial Services Commission and that her appointment was imminent as a judge. One, that's the first aspect that I want to clarify. And secondly, I will never in my life, especially not in the light of the various judgments of the SCA pertaining to various applications for advocates whose names were removed from the roll. The name of Advocate Seth Ntai comes to mind. I will never approach my opponent's client in order to solicit some sort of a settlement or some sort of intervention. Chairperson, I think that is the biggest atrocity in the legal fraternity that one can come across, and that is when, especially when senior counsel decides, well, I'm going to shoot over the heads of everybody and I'm going to the client directly. No, Chairperson, the answer to this dispute, this crisp issue, is simple and straightforward. You take my itemized billing of my cell phone records, and may I add, Chairperson, I don't have a landline. I don't practice in my office from a landline. I don't use a landline. I've taken my landline out years ago because it just distracts you. If attorneys want to get hold of me, it's on my cell phone or on my iPad. So there's no suggestion that I could have phoned her on the landline. I only use my cellular telephone. That's all I use. To take my itemized billing, to take her itemized billing for the month of November 2017, to compare it. It will be a matter of res ipsa loquitur.
Because that will tell you who initiated the call, and that will put an end to that.
Common sense and logic dictate that.
Yeah. I wonder whether any forensic investigation is needed to establish that. But
it doesn't look like, Chairperson.
Yes, yes.
As Mr. Botas correctly points out, it is simply looking at received calls and calls made. If
she accepts that the first discussion that she had with Mr. Botas on the matter was on the phone,
yes,
then, and if she accepts that Mr. Botas could not have spoken from a landline, then he could only have spoken to her on his cell phone. So therefore, Mr. Botas says, here is my cell phone. Whoever wants to check when, whether there was any call I made to her between that time and that time, here is the phone.
Yes.
And then she can provide her own to say, you know, let's have a look.
Yes.
I'm not sure that you need a forensic investigation. But again, as far as this commission is concerned, on the face of it, that doesn't appear to be an important issue to the commission. But she might persuade me when she gets a chance that there is something relevant in regard to who initiated. Okay, all right, yes.
The second issue, and in a sense, Mr. Botas, it seems to be tied to the first issue, is that you say she initiated the call, you congratulated her, and it is at that time that she pointed out the circumstances or the purpose of her appointment as chairperson of PRASA's interim board.
Quite correct, Chairperson. As I've alluded to earlier, I was surprised that she was deployed as interim or chairperson of PRASA's interim board, and I specifically asked her whether what the reason was for that deployment, because it's not ordinarily done in that fashion. And she then confirmed to me that she was deployed by the former president so as to clean up the mess and to sort the mess out. And what I understood, Chairperson, and she also said to me, there was numerous litigation and matters that were outstanding, and I got the impression she wanted to wrap all of it up and see which of the matters can she dispose of, which there's really no real disputes or there's no aspects which should go to trial, and the others to streamline it so as to make them trial ready or not. That's the impression that I got. But we haven't discussed it.
Can I, and to get past this point, Ms. Burgess, can I take it what you recorded at paragraph 11 in your response? That's 11, the whole of paragraph 11 is what really happened, and we can accept that that is your version.
Chairperson, you can accept it irrevocably and unconditionally. Yes, that is how it transpired.
Now, in response to the question of deployment, so she said to you, I'd been deployed by former President Zuma. She may not have used the word former President Zuma. Well, he wasn't former at that time.
No,
he was
she used the
president.
word, I recall the word, I was deployed by the president.
Well, I also wanted to ask on that, but I think you have made it quite clear because she denies that. And the actual use of the term deployed, is that the term she used, or is it your term that you used to in terms of what you understood her to be saying? Do you recall whether she used that term, or she may have used another terminology, but you understood it to be deployment?
Chairperson, I can't recall if the word specifically, the word deployed was used. It was definitely I was definitely informed by Judge Makubele that the purpose of her presence at the interim board of PRASA was at the insistence of the president, and that her function and her role was to clean up the mess and to sort things out. In Afrikaans, they say, nuwe besems vee skoon, and that is the impression that I got. This was a new broom and she had to clean up the stage.
Okay.
So, though this is where, Chairperson, I'm going to, I've read her affidavit, and it doesn't seem as if she says categorically she didn't say this. But what she says is, I don't know Mr. Zuma and so on. But I'm going to put two versions to Mr. Bottas, just for the purposes of not having to recall him.
No, that's fine. My understanding of her affidavit, but again, one might need to double check, and you can ask questions to Mr. Bottas on your own understanding of Judge Makubele's affidavit. My impression was that she was denying that she told Mr. Bottas that she had been deployed by President Zuma. And that's one. And two, she certainly did say she had never met former President Zuma before her appointment to PRASA, I think. But she does say subsequently, and in 2019, she was within the presence of President Zuma at a function at the University of Limpopo, in a graduation ceremony or something. Yes. But I think she says she had never spoken to him or something like that.
Yes.
So, but put it as you understand it. I wasn't sure whether she was denying using the word deployed as opposed to appointed, but she does say she was appointed by the minister.
That's right,
yes.
She does.
So put it the best way you can to put her version.
Ms. Burgess, she will come and explain, but I just want to put two possibilities to you. She seems to say at one level that she was not appointed or deployed by the president because she'd never spoken to him. Now, by implication, she seems to be saying that she didn't tell you that. What is your response to that?
First of all, Mr. Commissioner, I didn't read Judge Makubele's affidavit. I confirm unconditionally that she informed me that she was deployed or appointed as PRASA's, as the chairperson of PRASA's interim board by the president, not by the minister.
And she gave you at that time the purpose of that appointment stroke deployment.
That is what appears in paragraph 11 of my response to the Bar Council. Yes.
Now, she also seems to say that she never mentioned President Zuma in the conversation. As I say, I'm not entirely sure, but whatever her version is, I'd like you to sort of respond to all possibilities as appears from.
Well, I'm sure the answer has been given.
Yes. No, sure.
Yeah.
Finally, Mr. Burgess, I just want to, in fairness to you, because she is likely to come and make this allegation, she says in her affidavit that in 2018, you tried to approach her to resolve a dispute that Siangena had with PRASA. Can you recall that?
Yes, I can. It was shortly before Christmas. Mr. Johannes Krause was one of the attorneys, together with Mr. Tsepo Matopo. They were also involved in a separate dispute, chairperson, where Siangena featured. Senior counsel deals with that matter. I've got no idea what that matter consists of. Judge Makubele is 100% correct. During one of our conversations, I mentioned to her that I spoke to Johan Krause, and he mentioned to me that the Siangena matter, apparently, Mr. Chairperson, I haven't seen the papers or the documents. I think the quantum exceeds 1 billion rand. They asked me, in the light of the effective manner that we were able to settle Siyaya. I mean, it was in the open public domain that there was not one shot fired, and we settled it very, very easily, so to speak. And Mr. Johan Krause did approach me, and he said to me that the manner in which this matter with Siyaya was settled reach the ears of other litigants who have matters against PRASA. It seems that you and Judge Makuvele is on the same line, and you're singing from the same hymn book. What will your attitude or your response be if we engage you, Boetes, in that other matter as well? Surely it will also assist the parties to come to a settlement. And yes, I did mention it to her. I said to her, Nana, I believe that there's also pending litigation between PRASA and Siangena. What's happening there? Because I didn't know what's happened there. And her response was, that is a matter which is much more complicated than what we're dealing with. That quantum is something else, and we simply didn't pursue it.
She, just again for context,
Yes.
She puts it on the basis that she is saying because you initiated the Siangena issue with her, you must have also initiated the CIA. That's what her affidavit, because I'll just put that so that it's not out of context. She's saying, I am mentioning the question of Mr. Boutes's approach to me to settle the Siangena matter. She says, I'm mentioning all this as a basis to rebut the allegation that I initiated the settlement of CIA claims and that I told Advocate Boutus that I have been deployed to settle the matters. I just put that to you.
Chairperson, the attorneys for Siangena, Mr. Gert van der Merwe, did approach me. He phoned me and he asked me whether him and his client can, I think it's Mr. Mario Ferreira, can make an appointment with me so that I can become involved in that matter as counsel as well. I declined. I said, Gert, listen, Nick Maritz SC, Werner Luderitz SC, that's a big, heavy silk team that you guys have on board. There was a review application, I understood, Chairperson, that exceeds 3,000 pages and that they approached the Deputy Judge President for the allocation of a special court to deal with it. And I didn't at the time have the appetite to concentrate on a matter of that magnitude. The counsel that was appointed at that stage, I think, is some of the best legal minds that money can buy. So no, I didn't pursue it at all.
Okay.
Just finally on that point, and perhaps finally for the, in terms of your evidence, Ms. Boutus, she says that in regard to this, in January 2018, you sent her a letter. Can you recall that?
No, Chairperson, I didn't send any letters. I saw that that was something that was mentioned. If I did communicate, and that's my style, I communicate very often on WhatsApp and SMS for one reason, Chairperson, you have a paper trail. And secondly, yes, I did communicate with Mr. Mogashua via email. There was a lot of emails that was exchanged between us, all explained in the one email there. And the reason being, Chairperson, one of the, there was a postponement of the arbitration and then a dispute ensued. Who's liable for the costs occasioned by the postponement? And Judge Brandt didn't want to hear submissions on it. My proposal was that it should be cost in the arbitration. Mr. Mogashua's client insisted that the liquidated company should pay the costs, and that's actually where the correspondence ensued. I then sent Mr. Mogashua a very harsh worded email, and I said to him, Madimpi, but that's not what transpired. These are the facts. And this is what transpired because he started communicating with me directly via email. And all of that culminated in they filed heads, we filed heads of argument. And the end Judge Brandt said he can't determine who's at fault. And I think costs were, the award was each party to pay its own costs. So to answer your the statement, or what you put to me, Mr. Sony, no, I didn't initiate, I didn't write letters. It's not my function, my authority, or I don't have locus standi to write letters. Letters were exchanged between Mr. Matopu, and there are various letters, and also Mr. Kraus. I didn't write letters, no.
Chairperson, those are the questions I have.
Thank you very much. Thank you very much, Mr. Boutus, for coming to give evidence. We appreciate it, and you are excused.
Thank you very much, Chairperson.
Thank you.
Yes, thank you so much, Mr. Boutus,
Thank
on
you,
behalf
Mr.
of the Commission's legal team.
Thank you.
I want us to adjourn for a few minutes, and I would like to see you, Mr. Soni, and Ms. Rangata.
Yes.
Okay. We adjourn.
All right.
Yes, Mr. Soni. Your mic.
Chairperson, I've noticed you're having difficulty following the numbering in the bundles, and they have not been done in the usual manner. We would ask if we could be given leave to put the bundles right, and ask if we could take an early lunch adjournment so we can sort that out, and we could start again at 2:00 and go through the witnesses thereafter. I apologize again, but it is not fair to you, especially, Chairperson, because we may be familiar with the documents, but I noticed you were struggling to keep up with the witnesses and tally what was said in what's contained in the documents.
Okay, we'll adjourn early for lunch, and I'll give you a little bit more time. There are two ways of doing this. One is to paginate this bundle afresh, even manually, so that in the bundle I know that the pagination starts from page 1 and goes up to the last page, and it's sequential. At the moment, the problem is that different sections of documents in the bundle are paginated on their own.
Yes.
So if you say to me page 20, I've got to ask page 20 of which section. Whereas if you do it the way it's normally done, if you say page 20 on this bundle, I know there's only one page 20.
Yes.
So I can find it easily.
Yes.
There are two ways of doing it. The one that I've just said, or you could take out of this bundle Mr. Porter's documents and put them into a separate bundle. And then you keep the numbering that is on his. I'm assuming that, you keep that numbering. And then later on, you go on record to place on record that it's been taken out of this bundle. It's now on its own, and we give it a separate exhibit number and confirm that the numbering that was used, the page numbers that were used to refer to various documents during his evidence remains the same.
Same, yes.
Okay. And then you come to this bundle, which would then be minus Mr. Porter's documents, and then paginate it from page 1 up to the last document.
Page. Yes.
And prepare an index as one would do, which would be at the beginning. And then it retains the same bundle number and the same exhibit number.
Yes.
But the pagination is sequential.
Yes.
Okay, it's now nearly 25 to 1. So I think we'll adjourn and resume at 2. It gives you, I think, enough time to attend to this and to have lunch. And then to the extent that it may be necessary, we will sit until late-ish to try and finish as many of the witnesses as possible. Obviously, we will check their availability if we go beyond, when we go beyond 4 o'clock. But from my point of view, we could go even up to 6.
Yes.
But we will talk, and if tomorrow we are meant to have only one witness, or how many?
Two witnesses.
Two, but both of them are short.
Uh,
Or one is longer.
yes.
Mr. Dingiswayo.
Yes.
Is it? And then, yeah, okay. So let's see how it goes. Okay, we'll then adjourn and resume at 2 o'clock.
As you please.
We adjourn.
All rise.
Sorry.